And my topic is a little more philosophical and a little less scary, I think. The genesis of it is that I got involved earlier this year with a critical access hospital that was trying to work with another critical access hospital to create a system that would initially be the two of them, but that others might join, other critical access hospitals. Nationwide, there are, of course, many examples of hospital systems that involve large hospitals and large systems becoming larger systems and so forth. But when I started to look around, I could find no example really of a purely critical access hospital system. So I thought it might make a worthwhile presentation for the last 30 minutes of the morning, and certainly less focused on scary fines and penalties. So I'm going to jump around a little bit in the course of this and focus some on what's going on nationwide, or what we could find that was going on nationwide, and also a little bit about local problems and local inflexibilities. When I say local, I mean Kansas. So the good old days. We all wish that we had this again, I suppose. But the reason the slide is here is kind of to set the stage. Most Kansas laws for governmental hospitals, which is typically what a CH is in this state. There are some nonprofits, but most of them are governmental. Kansas laws were drafted at a time when this was what the model looked like. The Kansas laws were generally drafted in the 1980s. They've been amended off and on since then on a Band-Aid basis. Many of the laws that were adopted in the 1980s had as their predecessors laws, statutes that were drafted in the Hill-Burton days, back right after World War II. And so when you combine these statutes with what's called Dillon's rule, which I'll talk about here in a little bit, you get a pretty inflexible system as it applies to governmental hospitals. Today, of course, it is what we have here. And this is what's driving any sort of discussions on systems, affiliations, and so forth. At the acute care level, or the large hospital level, I guess I could say, there are various models that have been used to combine, coordinate, consolidate multiple hospitals and multiple systems. And these are just a few of them, the main ones, I think. So you have this typical clinical affiliation where we're all going to kind of get in bed with each other and say that we're aligned with whatever, pick a hospital and apply it. There are management agreements that go across an entire facility or just a service line for a large hospital. Joint operating company, which is the formation of a new company that operates multiple hospitals, but they have multiple hospitals each retain their own ownership of assets. Long-term lease. Member substitution is the one that probably is worth a couple comments, because many individuals that I've encountered that are administrators of hospitals are not familiar with this. For a nonprofit entity, it is relatively simple for someone else to become the controlling force. Nonprofit entities typically have members. Typically, the members are the board. And so what may happen is that a large hospital may enter into an arrangement with the littler hospital that is a nonprofit, by which all those board members resign and the new large hospital is substituted in their place as a member and appoints a new board. The members are the ones that have the authority to appoint board members. Typically in a nonprofit, the board members and the members are the same. And the rest of these you've all heard of, some sort of merger, asset purchase, so forth. This is another way of presenting what occurs with larger hospitals. And the highlighting is really a mistake on my part. When I set up this slide, I was thinking, well, what hospital, what of these types of arrangements have involved purely CAHs? purely critical access hospitals, at least in my experience. And I highlighted the ones that I've seen, but as I looked at it this morning, there's been a hospital merger in this state of two critical access hospitals. Two districts came together. There certainly are formal affiliations with a larger system, affiliating with a small CAH. There have been a few arrangements or transactions I've seen in which non-care assets have been purchased or sold. I have not really seen a shared services cooperative, a JOA, a clinical department consolidation. I have seen some clinical affiliation. So most of these have occurred in this state with CAHs, but for the most part, they've also been arrangements with large systems. You won't find much that is CAH to CAH, which was kind of the issue that I was presented with earlier this year. So to kind of step back a bit and talk about affiliation or consolidation that may occur between a CAH and a large system. You could have a lease or a management agreement. That's fairly common. You could have the member substitution that I just mentioned, and with a governmental hospital, the governmental hospital has a board that's appointed or elected through the commissioners in some way, depending on exactly the structure. So what typically has to happen is that the governmental hospital has to enter into a lease with a new entity that becomes the operating entity, and then the larger system is either the member in that new entity or has the right to nominate the board and generally control it by putting its acceptable board members into as the operating entity. Deal points involved with this. These are just a few of them. How involved is the system going to be? What requires local approval? How much money is the system going to put in? How's it going to enhance services? What are the exit strategies on the part of the local entity if it becomes dissatisfied? That's typically what a affiliation of a small CAH looks like when it becomes part of a larger system. Some version of this. But it isn't all good and it isn't all bad. And these are a few headlines from recent publications. The second and third bullet points are, of course, what the local entities typically are concerned about. They recognize that their new hospital or their local hospital can become more profitable, have better margins if it's under the management and has the efficiencies of scale that a large system might bring to the table. But they're concerned that ultimately the access to care for local people is going to be reduced because services will be reduced in some way. And then the last bullet point is kind of the ultimate concern. There you have Ascension that took over as the member of a small hospital in the District of Columbia, had the right to elect the board, and the board didn't do what Ascension wanted it to do. So Ascension removed the entire board, and so a local board, in negotiating an arrangement with a larger hospital system, should be aware of that, typically is, and that would be concerning also. So nationwide, rural hospitals are becoming affiliated with typically with larger systems, although as this slide indicates, Kansas is not nearly it's not nearly as prevalent in Kansas as in Oklahoma, as just an example. But nationwide it's happening. More people are calling, more hospitals are calling. There are more solicitations, more opportunities to do this, more consultants, etc. Anyway, in Kansas, let me start at the bottom actually. Nationwide, there are very few systems composed entirely of critical access hospitals. I'm going to talk about one here in just a second. In many states, there are support networks for critical access hospitals that basically sell services and provide generalized support and expertise to help critical access hospitals. In this state, of course, you have Great Plains with its managed and leased hospitals, and then you also have some system affiliations with small critical access hospitals, coordinated, consolidated, affiliated, whatever term applies, with a larger system. but it's not that prevalent. And for the most part, most critical access hospitals, in my experience, are still trying to maintain some level of independence, but they know that the time is coming. So this is an example, though, of one in New Hampshire, about the only true critical access system that I was able to identify. There are some others, but this is the best example. North Country Healthcare, and it involves 4 small critical access hospitals, with one, Littleton, being larger than the other 3 and much more substantial, but still a critical access hospital. This was all put together back in 2015. All of these are nonprofit organizations. Littleton, as I said, was the largest. It was also the best off financially. And after less than 4 years, it decided to exercise its right to leave the system. So anyway, the way this was set up was that North Country Healthcare became the member of all 4 of these hospitals and had the right to elect the boards. The 4 hospitals in turn elected representatives to the North Country board. And let's say I have a little bit more detail here. General goals of this system are what you would expect: enhanced care, regional network, clinical integration, and so forth. As I just said, each hospital remained a separate hospital, separately licensed, own board, own responsibility for decisions, but subject to shared decision making for various matters. And in many of these issues, operational issues, key operational issues, required a supermajority, which in this case was defined as 2/3 of the hospital board, whatever hospital we're talking about is the key element. 2/3 of each board of the other 3 hospitals, and 2/3 of the North Country board. So, as I said, North Country is sole corporate member of each of the 4 hospitals. Affairs to be managed by the board of directors, consisting of 17 members with 5 ex officio. And the 5 ex officio were the board chairs of the 4 hospitals, CEO of North Country, and then other representatives, with Littleton having a disproportionate share because of its financial situation and size. And so they operated for 3 or 4 years. They had supermajority issues, as I just referenced, and then other issues, and everything was to be shared. Now, this particular slide, you will get the pop-up or plug in the number to get the credit. So I'll give you a second to do that. And then I'll go on here because I'm about to leave this slide. Just wait a second here. I still see some numbers popping up. So, okay. I'll go back one more time. I'm sorry. So as I said, I kind of lost track of exactly where I was. This was organized similar to about any affiliation or consolidation that you would see at a larger hospital level. The one kicker perhaps is that the voice given to each of these small hospitals on a supermajority basis for most substantial operating decisions. But in general, the idea was a shared decision making where actions were taken at the local level and had to be approved at the parent or the North Country level. Anyway, the structure of it was that North Country acted as a system and provided services through a management services agreement, but any deficits were funded on an allocable basis by the participating hospitals. There was a commitment on the part of North Country to maintain core services at each hospital. but they anticipated regional coordination and clinical integration. And here's the kicker: the withdrawal window was 90 days notice beginning on the 3rd anniversary date of the closing. And they, had a 90-day window beginning on the 3rd year anniversary of closing. There was a withdrawal payment that was owed, but it was not that substantial. And so Littleton, after 3 years, said, "I'm out." And that's the problem that happens, in my experience, with critical access discussions, is that to be sure that they're successful, the system's successful, there has to be a time commitment, not only a financial commitment, but a time commitment. And 3 years probably wasn't enough. But that was the structure of it. So I'm going to kind of shift gears. As I mentioned earlier, Dillon's rule. Kansas law goes back decades, literally. And so there is a judicial rule called Dillon's rule that is used in interpreting the authority of governmental hospitals. Now, I'm kind of shifted gears from nonprofits, as we were involved in North Country, to governmental hospitals, which is most CAHs in this state. In this state, Dillon's rule says, in effect, that the authority that a governmental entity might want to exercise basically has to be spelled out in the statute, or has to be implied from the statute without being spelled out, but has to be closely linked to the language. In other words, governmental agencies typically do not have broad-based authority. They have that's spelled out in the statute, and that which you can apply directly from the language, and no further. This has been a problem historically, and so we got rid of it because through home rule years ago for cities, counties, more recently, school districts, more recently yet. But the rule remains applicable to governmental hospitals. And when you start talking about any sort of affiliation agreements or arrangements involving governmental hospitals, you quickly run up against this. And I cited there the best judicial example in which the 10th Circuit Court of Appeals, which encompasses Kansas, held that Edwards County Hospital could not enter into a fixed term employment agreement with its CEO. The language of the County Hospital Enabling Act makes clear that a county hospital can employ a CEO, and that's what was said, what it said at the time of this case. Didn't say anything about fixed term employment, a specified number of years, in other words. And the court said, well, you may be able to employ him. That doesn't mean you can fix the term, which seems sort of ludicrous, but that's kind of the result of this Dillon's rule that I just referenced. In addition, in Kansas, a county hospital, at least, title to the property of a county hospital vests in the county where the hospital is located. And so this has been the basis for several attorney general opinions on real estate outside the state or outside county boundaries, in which the attorney general has said, well, you can't own property in another county because of the statute that says it has to be vested in the county where the hospital is located. So these are some restrictions that are in Kansas law that make it difficult for a governmental hospital to enter into an arrangement that involves some other facility in some other county. And we're kind of running short on time, so I won't do much a deeper dive into it. But just to say that the combined element of Dillon's rule that says you have to have the authority spelled out in the statute before you do it, and then this ownership interest, or restricting ownership to the county in which the hospital is located, can substantially limit the ability of a county hospital or a governmental hospital to enter into consortiums or arrangements. This is the most famous opinion. Involves a county hospital that wanted to open a clinic in an adjoining county in which there was no clinic, there was no hospital, there was virtually no medical care. the Attorney General opined that that you couldn't do it. You couldn't form a nonprofit corporation even and fund it to own and operate the clinic, because of the requirement as to who owned the property. You could, in other words, you couldn't own a clinic in one county because of the law that said it had to be vested in the county where the hospital was located. The more key element, though, is that there's language in enabling acts for governmental hospitals that talks about the ability to enter into a joint enterprise. And so the Attorney General said, well, that's fine, but because of these principles that I've just been discussing, a joint enterprise is subject to the limitation that it be located in the same county as the hospital is. And so that gets you into the question, of what is it that a governmental hospital might be able to do beyond, if anything, a joint enterprise with maybe its physicians in the same county. For example, how would it enter into an arrangement with other hospitals to have a centralized lab or a higher level lab? Is that even possible? It lacks the clarity. Let me get back up. And so the bottom line in Kansas is that there's no clear-cut mechanism to combine or consolidate governmental hospitals. There is a mechanism to put district hospitals together, but if a county hospital wants to consolidate services with another neighboring hospital, there's no clear-cut way to do it. About the only thing that the County Hospital Enabling Act says is, or provides, is a mechanism to close the hospital. It doesn't say anything about how you would combine with other hospitals into some form of joint venture. It's totally lacking in detail. And the effect of this Dillon's rule is probably to say that you can't do it. Now, I understand many hospitals are ignoring that, and probably rightfully so, but nonetheless, the state of the law at the moment is that governmental hospitals kind of operate in this silo within their district, county, or city, and shouldn't go outside boundary lines, at least according to the strict interpretation of the law and the Attorney General opinions. So coming back to this North Country thing, if you wanted to do that in this state, what you would end up doing is creating new entities, which are kind of the second level of boxes there, County Hospital A, Inc. as the lessee. They'd all be lessees. They would lease from the hospital board, and below the hospital board, you would have commissioners, county commissioners. Now, I'm assuming these are all county hospitals rather than nonprofits. And the reason you would do that is because Kansas law allows a lease of a governmental hospital to another entity or a management agreement, but it says nothing about just a joint venture consolidation sort of system arrangement like North Country is or was. This would be a cumbersome structure. It could be done, and so, but it would be a very cumbersome structure. And so what the basic point here that I would make, and I've kind of dashed through these slides, it's taken me a little longer than I had anticipated, is that critical access hospitals should, I think, be able to enter into the same sorts of structures that their larger hospitals enter into. Nonprofit critical access hospitals have the flexibility as nonprofits to do this, as demonstrated by North Country, even though that's in New Hampshire. If it were for Kansas CAHs, they could get to the same point. But governmental hospitals, because of some of the limitations of Kansas law, do not have that same ability. It would be very cumbersome to do that. You could get there, but it would be very cumbersome. And so kind of philosophical as a point of personal privilege, I guess I would say that when politicians in this state are talking about preserving and protecting rural health care, what they maybe ought to be thinking about in part is amending some of these laws and overturning some of the court decisions to allow CAHs and rural emergency hospitals, for that matter, to combine and consolidate in ways that their larger brethren do pretty routinely, without the necessity of all sorts of structure and cumbersome requirements. So with that, I think it's time for lunch.